Let me stop you.
Sure.
Why did you think that arbitration would be preferred over mediation?
Because that's closer to what lawyers know.
Okay.
I go back to my Josh Stolberg story. You know, if he had said he was going to run an arbitration program, I probably would have understood it.
Mm-hmm.
But mediation, it's an informal process. You know, it's not. There's not. Well, in those days, even in the mid '80s, no schools taught mediation.
Mm-hmm.
Arbitration's like adjudication. You know,
Mm-hmm.
the arbitrator sort of acts like a judge.
To the draw of the familiar.
Yeah, and I think that's right.
Mm-hmm.
I should have been much more farsighted. I think one of the reasons why it's captured the imagination of lawyers is that it's different.
Mm-hmm.
And I think lawyers, particularly trial lawyers, I'm always amazed at the trial. The chair of the commission in Florida, Larry Watson, and if Larry's watching this, I apologize, Larry, but Larry Watson was a Rambo trial lawyer. He was head of the litigation section of the Florida Bar. He's still active in the litigation section of the ABA. Now, why would Larry Watson, this Rambo trial lawyer, become interested in mediation? Well, I mean, mediators do something that's somewhat different than trial lawyers do, but a lot of the skills that mediators have, the analytic skills in particular, are very similar
Mm-hmm.
to lawyering skills.
Mm-hmm.
And I think they just became intrigued with it. I thought they'd oppose it. I remember, again, being on that rules committee, the first rules committee was chaired by David Strawn. And David couldn't make the presentation to the Florida State Bar Board of Governors on our recommended rules. So I went down to, I think it was in Gainesville, actually, wherever it was. Orlando. I went down to Orlando and made this presentation at a bar meeting to the Board of Governors. And they had some concerns about the rules. You know, why weren't we swearing people into mediation? Wouldn't they lie? And I knew you'd appreciate this. And this was probably the big concern. You know, how are we sure people are going to tell the truth in mediation? Well, you know, and we got into that. But again, even then, I thought, well, mediation, it's going to be there. But you know, number one, I didn't think I thought the lawyers would see it as not in their best financial interests. But if I'd really thought about it, it is. I mean, trial lawyers, the plaintiff's bar operates generally on a contingent fee basis, so they're going to get their money sooner. It may be a little less than if they went to trial, but trial's always a crapshoot. So, I mean, it's possible that they're not going to get anything at trial. So this guarantees them something, and it guarantees it to them sooner. So, okay, I began to understand the plaintiff's lawyers are probably going to like this thing. And then the defense bar operates on the clock. Well, they're not going to like this, but heck, their clients love it. You know, particularly the insurance companies at the beginning. And they're not going to go against their clients, particularly their big institutional clients.
They want more business.
Yeah, so everything sort of stacked up in favor of, and it really took off in Florida. I was amazed at how quickly the bar became intrigued with mediation.